matter of Abbey Healthcare Limited and Simple Contractual.
Yes, Mr. Ryan.
My Lords, I appear for the appellant, Abbey Healthcare. My learned friends, Mr De Gregorio and Miss Jaya Kumar, appear for the respondent. My Lords, there should be two bundles before the court, an appeal bundle and an authorities bundle.
Yeah.
Lord, there is also an insert, regrettably the ground for appeal is not included at the back of the appellant's notice in tab 2. That has now been inserted, and I trust that's
Thank you.
inserted at the back of the bundle. My Lords, I approach the submissions in 6 parts. First, introduction. Second, facts. Third, the Housing Grants Construction Regeneration Act of 1996. Fourth, the building contract and the collateral warranty. Fifth, Parkwood. And finally, the judgment below and disposal. Turning to part 1, introduction. The issue on appeal.
Before
yes.
you embark, just to some housekeeping, if we may. We have a ground of appeal, and we have a respondent's notice, and the ground appeal focuses on, as it were, the narrow point as to whether, in this case of this particular warranty, the judge was right to reach the conclusion he did about the applicability of the system to it. The respondent's notice raises a wider question about the, as it were, status of warranties generally,
Yes.
with regard to the system, and your list, as it were, doesn't pick that up. In fact, the respondent's notice, as it seems to us, is an anterior question, which, as it were, overhangs the whole appeal. Clearly, you're going to be in a position to respond to the respondent's notice once you've heard how it's presented by Mr. De Gregorio, but we're going to have to make sure that the shape of the hearing allows for both matters to receive appropriate attention.
Respectfully, I absolutely agree with that. I've structured my submission such that both are covered. Obviously, there is the narrower ground, as you say, of the particular contracting issue here, but overhanging that, there is the broader issue of whether collateral warranties at all should be subject to the Act.
Exactly.
And I will cover that in some detail, particularly when dealing with the Act under Part 3 of the submissions and the provisions made in Section 104. So I will ensure that those are covered, and to the extent that any further is replied, it is necessary then. Right.
So you can take your own course as to,
yes.
As to the extent to which you as it were, get your response to the response notice in when presenting the appeal. But tell us, secondly, how have you decided to divide the time up between you?
Yes, roughly half each, my Lord. I understand this. I think this hearing has been listed for 4 hours. We'll be in your Lordship's hands, obviously, as to how that proceeds. But I'd be confident of finishing within that time. I suspect a certain amount of the ground I traverse in terms of the Act and the relevant contracts will reduce the time.
Well, I think the 4 hours was my estimate, and obviously that was before the respondent's notice.
Yes.
But I think, as my Lord has indicated, we're entirely confident that, notwithstanding that, it can be a day. But
yes.
we were simply anxious to ensure that you left sufficient time to reply should you need it.
Lord, I'm very grateful for the indication.
Well, we work on the basis that you'll be aiming to finish by lunch or,
yes.
or shortly before then.
My Lords, I'm grateful. Just picking up the point then of the broader ground, in terms of my introduction now, may I set out in summary what our position is on the broader ground before I turn to the narrow ground. So on the broader point of the principle, in essence, the respondent's position depends upon reading in glosses and words which do not appear in the statutory text within Section 104. Most significantly, that in order to be a construction contract, the respondent asserts that one party must agree to carry out construction operations, but the counterparty must in return agree to pay for those operations. That appears at the respondent's skeleton at paragraphs 75 and 97, and the respondent refers to such an arrangement as being, quotes, a true construction contract. That term appears at paragraph 89 of the respondent skeleton. The appellant respectfully disagrees with that formulation. It's not appropriate or necessary in this case to add words into section 104, which is a clear statutory test and which we submit is unambiguous. One simply asks, under section 104, whether the contract is for the carrying out of construction operations or limbs B and C, the arranging of construction operations or the provision of labour. Remuneration and the party responsible for the remuneration forms no part of the test under section 104. Section 104, as I will come on to, is widely drawn in its terms and it's straightforward, and we submit it should be given its ordinary meaning on the words which presented in the statute. I accept there are less straightforward questions on this statute, particularly concerning section 105 as to which particular operations are within or outside of the Act, but happily those matters don't arise on this appeal. We're concerned principally with section 104. So in summary, there is no exclusionary approach, no one-size-fits-all when it comes to collateral warranties under section 104. There is certainly no rule of statute or of law which excludes collateral warranties in principle from the definition under section 104. On the contrary, it is clearly envisaged that, provided they are a contract and for the carrying out of operations, that they may be construction contracts. The points of principle which Mr Justice Aikenhead derived at paragraph 23 of Parkwood, which I'll come on to later, are with respect sound, and I commend the court to endorse those observations. So that's the broader point of principle in outline. I'll expand upon that, my lord, when considering the Act itself in part 3. On the primary issue, the narrower ground between the parties on this particular contract, well, the starting point is, of course, the express terms, and in particular clause 4.1 and 4.5. I would respectfully ask the court to turn that up briefly. It's on one page, page 294, tab 13. At page 294, we have the material terms of warranty in clause 4. And one sees under 4.1a, the contractor warrants that the contractor has performed and will continue to perform diligently its obligations under the contract. And in 4.1b, in carrying out and completing the works, the contractor has exercised and will continue to exercise all the reasonable skill and care. The express terms impose contractual duties on the respondent to carry out and complete the works. To put it this way, to the extent that the respondent does not carry out the works at all, or does not complete the works, or does not carry out the works in accordance with its obligations, there will be direct contractual remedies in the appellant in respect of that, not just in respect of damages, but potentially locus to seek injunctive relief, albeit obviously much harder to obtain.
But the remedy is not in relation to the underlying contract. It's for the breach of the warranty.
My lord, yes.
Which is conceptually different.
My lord, in terms of how the obligations are phrased, and we must, as a starting point, begin with the express words, it uses the language of the statute. So under 4.1b, in carrying out and completing the works, the contractor has exercised and will continue to exercise reasonable skill and care. So, taking my lord's point, it cannot be said that this particular contract is a mere warranty of a statement of affairs. It does provide far broader terms than that, and in particular they refer to the building contract, they refer to its past performance, its future performance, and the obligations on the respondent of doing certain matters, in particular the carrying out and completion of construction operations. They are expressed in those terms, and they mirror, at least within clause 4.1b, the language of section 104. The terms here are retroactive in effect, and the appellant places some emphasis on that. They impose continuing obligations on the respondent for the carrying out of works. The upshot of retroactivity is that these obligations are deemed contractually to be effective from the outset of the works, notwithstanding that the warranty only came into existence at a much later date. The parties have, in essence, agreed that the collateral warranty takes effect looking forward, and that the obligations to carry out the works are deemed by agreement to be actionable as such. With those,
there's no doubt that any breach of the warranty is actionable. So nothing to stop somebody in your client's position suing. And that's not a problem, is it? It's the means by, it's the range of remedies that are available to you that are in question.
My Lord, undoubtedly the remedies are important, but we would also place emphasis on the underlying rights. The cause of action here is not simply in respect of the past tense has performed or has carried out. It necessarily encompasses, due to the retroactive nature of these terms, the future-looking obligations, the obligations to continue to perform and carrying out and completing the works. And the importance of that, my Lord, is that we say in construction contracts, the cause of action for defective works accrues up to and at practical completion. So for those purposes, there is a very real importance attached, not just to the past obligations, but also the forward-looking obligations. And we make the claim in respect of all of those obligations. So I respectfully agree, it is obviously a matter of remedy, whether the remedy of adjudication is available and what remedies attach. But the underlying rights are important here because they are expressed widely, and we are seeking to enforce those rights, and all of them, not just the past state of affairs. The lower court, my Lord, focused upon the date of physical signature of the warranty, the date of execution, as if it were determinative of whether this contract was a construction contract. And at paragraph 27 of the judgment, which I'll come on to later, the court proposed guidance that not only are the terms of the warranty of importance, but parties should pay heed to when their warranty is physically executed. The appellant would respectfully suggest that was novel guidance, not based on authority, and we would suggest erroneous. It focuses, we say, on form over substance at the expense of the express terms, and it fails to pay sufficient regard to the retroactive nature of the terms, which I've just outlined. Whereas the date of
well, on one view, it doesn't pay any regard to the retroactive nature of the contract at all.
At all, yes.
It's not a question of it being there, but perhaps not. It ignores it.
My Lord, yes, and you'll see from the skeleton, we place weight on that, and it raises a significant practical problem here. The cases which look at retroactivity, in particular, Northern and Shell and the Swansea case, which I've cited, the court there finds that the date of execution is irrelevant to the question of retroactivity. Even though the contract comes into existence much later, you don't get 12 years from when it is signed, you have 12 years from when those retroactive obligations came into effect.
Well, you have 6 or 12 years from the date of practical completion.
Yes.
Because for defective work, the law is the cause of action accrues on practical completion under the contract, and in Swansea, Mrs. Justice O'Farrell found that's when the cause of action accrued in relation to the retrospective warranty too. So, in fact, the cause of action accrued before you've got the warranty.
Yes.
But that can happen, certainly in circumstances where the beneficiary under the warranty is, as here, the tenant.
Yes, my Lord, I gratefully accept that. It does give rise to an oddity, though, that the date of execution is not relevant when construing the warranty for the purposes of retroactivity, i.e. the substance of the terms. But when one is looking at the substance of the terms as to whether it is a construction contract, under this new guidance ventured by the lower court, it suddenly becomes relevant. That gives rise to attention in our
Well, doesn't it depend upon how you interpret the particular contract that you're talking about? Because Mr. Justice O'Farrell was talking about the fairly common situation where building works are carried out before, but people haven't actually formalised the contract. If this is to be treated as a warranty of a state of affairs, rather than effectively entering into a construction contract, then different considerations could apply, couldn't they? Because you would simply, if this is, as respondents say, simply what would normally be regarded as a warranty as to a state of affairs, then you simply look to see whether the state of affairs has been broken. But arguably in those circumstances you couldn't have a cause of action under the warranty before the warranty itself is executed.
Well, Lord, yes, I accept that point. In terms of the exercise we have here, though, our principal submission is that the thrust of these obligations is not as a state of affairs. And indeed, what one would see if this was a warranty of a state of affairs, it would be a much simpler formulation along the lines that the works are of satisfactory quality, or that the works shall have a service life of 10 years. They would not be phrased in the way that we have here over multiple clauses of in terms of performance or exercising or carrying out of operations. And that we say is a material difference here. In turning back to the date of physical execution or signature, we say in relation to that warranty point, the lower court has misapplied the dicta in Parkwood at paragraph 28. So in Parkwood, Mr Justice Aikenhead gave over the dicta to the effect that where there are works still to be undertaken, still to be done, that may well give rise to an inference that this is a construction contract. Whereas if the works have already been completed and the terms are merely warranting a past state of affairs, that is less likely to be a construction contract. We respectfully say that the lower court has misapplied that dicta, specifically in that Mr Justice Aikenhead was not suggesting as a blanket rule that if works have been completed, then the warranty is necessarily, the instrument is necessarily just a warranty. His lordship was still requiring there to be an analysis of the substance of the terms as to whether they are in substance a product warranty, or whether, as here we say, a broader or more sophisticated package of rights which concern in terms the exercise of operations.
Do you accept that it may be that the feature that the works have all been finished before what we'll non-tendentiously call the collateral warranty is executed may be a relevant factor?
It depends on the substance of the terms, my lord. If the terms as here are on their proper construction.
No, I know your case is that on this case, on this particular agreement, but I just wanted to be clear that at least in principle, the timing of the execution of the collateral warranty could be relevant, depending upon its terms.
My lord, I don't think the appellant would accept that. The timing of the warranty inextricably is linked with the terms, and it cannot be, we say, that same terms as, I mean, in this case, as my lordships may have gathered, there were two warranties. There was the top-hand warranty given to the freeholder in precisely the same terms before practical completion, which on the court's analysis is a construction contract, whereas we have the Abbey warranty here, which we're dealing with, in precisely the same terms, executed after, i.e. a timing point, which is not. So on that basis, we would not place emphasis on the timing of the warranty. First and foremost, the court has to start with the express words and the substance. Well, just finally, in opening on the terms of the warranty, my lords will also have to grapple with the issue of this warranty. It provides a form of obligation phrased as a warrant, as opposed to an undertaking or an acknowledgement. There is some emphasis placed by the respondent on this point. That does not affect the outcome here. Again, the court has heard my submissions in outline. Clause 4 gives binding promises in extensive terms as to the carrying out of operations, and that given the breadth of the obligation requiring the doing and the carrying out of those works, that is sufficient. The warrant is in effect a promise. That is sufficient for the purposes of section 104. And to suggest otherwise would be what Mr Justice Aikenhead warned against, namely a peculiarly syntactical analysis or a straight-jacketed interpretation.
Could we go back to 292?
Yes.
Which is where this document, which is a 2020 document, 2020 document, begins the contractor's collateral agreement.
Yes.
And that, I think, was in 2020, wasn't it?
My lord, yes.
Yes. And we go on to page 293 as it unrolls in order to get to where you took us to, which was on the second page of the terms.
Yes.
In these circumstances, is there anything to prevent the agreement between simply Abbey Care and indeed Topham from saying that if there's any disagreement between them, they have to go to adjudication, or there's a right to adjudication?
My lord, there's no express term in the warranty.
No. Is there anything to prevent there being such a term in the warranty that would be effective in your favour?
My lord, no. No, the parties could have included express terms of a right of adjudication. But there is nothing exclusionary about the right. If the parties expressly agree it, then even if the operations, the underlying operations, are not within the scope of the Act. So a key example, which my lords may be familiar with, is power generation. It's expressly excluded from the Act. If the parties nevertheless include their own terms as to adjudication, that applies.
So although it's a statutory system and regulated, you can opt in.
My lord, yes.
Even if you don't fall squarely within 104.
Quite right.
Right. So one could envisage the agreement including such a term, but in practical reality it would only do so if the main contract had provided for that to take place. This is an agreement which simply entered into because it had to, not because it wanted to. And so there's nothing to stop it, including those terms, but those terms are not going to be included in practical reality unless there's an obligation in the main contract.
That's quite right, my lord. So this warranty exists because of the construction contract, as my lord has alluded to. There are obligations.
So is there anything in the construction in the rules that relate to the construction contract that would prevent the term that provides for collateral warranties to be granted from saying, and those warranties may include adjudication provisions?
My lord, no.
It could have happened at two stages, couldn't it? Because the form of warranty was annexed to the construction contract, or a form of warranty, and so it could have been written in at that stage. And I do not know, because I haven't checked, whether this warranty was in fact in every respect the same as as what was in the Annex 5 or whatever it was.
It is materially identical. There are differences in numbering,
Right. But it could have been written in at that stage, even though it wasn't written into the Annex 5. When the parties came to agree to a collateral warranty, they could have written in at that stage.
Yes.
Any dispute should be referable to adjudication.
My lord, yes. As to that point, though, we would say it's not determinative or relevant. I mean, there are frequently
but for the future,
where they are excluded.
For the future, people might begin to contemplate writing that in or not, as the case may be.
But potentially, my lord, that would obviously give rise to significant practical difficulties in the industry, in that construction contracts take place over a very long period of time. Many will already be in existence or about to come into existence, and it would disturb the understood approach following Parkwood, that provided that these warranties are parasitic upon the building contract and that they emerge as a result of them, that they will be construed as typically as construction contracts.
But you've got there's a greater problem, isn't there, for somebody in your client's position who are not concerned with the negotiation of the head contract, that unless somebody had included an adjudication provision in the head contract that said that a warranty has to include an adjudication provision, you'll never get adjudication.
My lord, that's right.
Unless you get in under 104.
That's exactly right, my lord. In this case, Abbey, which is my client, the tenant, it was not in existence. It hadn't been created as a company at the time of the building contract being entered into. it didn't have any say over what those terms were. So unless there were either express provision in the Act which displaces any argument that we're having today, or alternatively, the Section 104, this contract is within the Act.
You're
left without that particular remedy.
Right, we are left without it.
At the moment, I'm afraid I don't understand that. Are you saying that because Abbey comes after the construction contract, the main contract has been written and agreed, you cannot negotiate or agree a term that the disputes arising under the warranty will be referable to adjudication?
Well, Lord, in essence, what we had, I think the answer is no to that, my Lord. What we had here is Part 8 proceedings for us to obtain this warranty, and the obligation on the respondent was simply to provide the warranty in that specifically set out form. So there was no scope for my client providing for express terms.
Or once you sign up to this, but I'm obviously missing something. For my part, I don't understand why, when it may not have worked, but in principle, I don't understand why such a clause could not be written in at the time that the collateral warranty is entered into.
Well, the respondent is under no obligation to include that.
I agree, but in principle, it could be done.
Well, my Lord, yes, but there'd be no legal basis to compel the respondent to do so if the court were not with us on Section 104. That's part of the reason why Section 104 is so important, because in cases such as this and many others, construction contracts.
Well, that may be an indication of where the interpretation should lie now.
The court should not be placing determinative weight on what particular express terms the parties could have included.
No, I accept that.
That's not a legitimate.
Right. So I got you into this discussion, and where we come out on your submission is that the fact that you could have an express term in a warranty for adjudication is in reality of no comfort to somebody in your client's position, regardless of whether they were just formed or not. They could have been around for 100 years, but they're late to the party in terms of the building contract, the main contract, and they have no influence over what's in the main contract, or may not have had any influence. And unless in the main contract they were given an express term, they're not going to get it in all probability as a warranty.
Yes, quite.
All right. I followed that through, right or wrong.
Yes, and that's part of the context which the court must consider when considering, namely, it doesn't really affect the task which the court is to undertake, namely an application of Section 104. Are these terms in substance for the carrying out of construction operations? So, my Lord, that's an introduction which I hope the court has found helpful. If I could turn briefly now to the facts, part 2. My Lords may be familiar, but I wish to just set everything out in case it becomes relevant. The building contract is at tab 12. Sapphire Building Services Limited engaged with the respondent simply. Dated the 29th of June 2015. The contract price was just around £4.7 million. It was the contract to design and construct a care home. In terms of the works themselves, simply respondent to commence those works on the 11th of May 2015, prior to the building contract having been executed on the 29th of June 2015. Practical completion was the 10th of October 2016. During the works, the respondent provided a collateral warranty to Topan, the freeholder of the site, in materially identical terms to that before the court. That was the 15th of October 2015, a year before practical completion in October 16. Abbey, the tenant, the appellant, was incorporated on the 20th of October 16 after practical completion. At tab 16 of the bundle, my lords, there was then a settlement agreement between Sapphire, the original employer, and the respondent, simply the contractor. That was the 13th of June 2017.
Which tab was that? Remind me.
Yes, it's right at the back, my lord, tab 16.
Thank you.
And at page 362 of tab 16, clause 2 provided for a final statement sum which is in effect a settlement sum agreed between the parties. And clause 2.3 provided that payment of that sum shall be in full and final settlement of all claims, causes, rights of action, howsoever arising under the or out of the building contract. Clause 2.4, which is at page 363, provided an express carve-out from that settlement for latent defects, and we are concerned in this case with latent defects. At clause 4, there's provision for a deed of novation to novate the building contract from Sapphire as the employer over to Topan as the employer. And that novation agreement appears at page 366 and following. It was executed on the 14th of June 2017. In August 2018, fire safety defects were discovered at the care home during a proposed sale of the care home. In January 19, Topan, the freeholder, wrote to the respondents to request rectification. No remedial works were forthcoming, so a third-party remedial contractor was engaged. The third party commenced remedial works 25th of September 19, completed those works 14th of February 2020. There were then requests by Topan under the building contract as the substitute employer to have the respondent execute the Abbey collateral warranty in favour of the tenant, the appellant. Those requests were refused, and Part 8 proceedings were commenced in August of 2020 to compel the execution of the warranty in favour of Abbey. 23rd of September 2020 simply executed and delivered the deed, and the 23rd of October 2020 Abbey executed the deed. There then followed adjudications by Topan and Abbey. The notice of adjudication is at tab 14.
This is in the Abbey adjudication.
Yes, yes, my lord. So the notice of adjudication.
You said there was a warranty, that the adjudication between Topan and Simply Construct,
yes,
was on what?
Under the building contract, my lord.
That was under the building.
As a novated employer, yes.
As the novated employer.
Yes.
Right. Although there was a separate warranty.
Yes, my lord. So the Topan warranty was provided during the work.
Yes, that was the one,
October
15th of October 2015.
Correct, my lord. Yes.
But the until they became the substitute employer, that would have been Topan's route to Simply Construct.
Yes.
But following the novation, obviously it was the building contract.
Yes, my lord. That's quite right.
Yeah.
In terms of the adjudication itself, the respondent challenged jurisdiction on the basis that the dispute was too nebulous or ill-defined, had not crystallised, and also it took the point now taken that this was not a construction contract. The former...
Do we have their response?
Not in the bundle, my lord,
no.
Right. No, we have the notice of adjudication, which commences the process jurisdictionally, or not, as the court will find, and then the decision itself is at tab 15.
Sorry, so in the Abbey adjudication,
Yes.
the point, what were the points taken?
Yes. Can I take the court, please, to page 324 of tab 15? This is the decision. It includes, helpfully, the jurisdictional objections that are taken.
Okay.
So 324.
Yeah.
The court will see a number of jurisdictional points were taken on the Abbey adjudication. 2, nebulous or ill-defined, dispute had not crystallised, and then also that...
How many times is that objection going to be taken and rejected before people decide it's a completely hopeless point? I mean, the number of times people take it, I've never seen it be successful. 25 years in adjudication doesn't stop solicitors whining on, making the same rubbishy point. Anyway, there it is. It didn't succeed. There's a surprise to us all.
Yes. The decision which hopefully the court is in at tab 15, it awarded damages and interest and unpaid fees of just under £1 million.
Well, whereas 8.2 aren't we? Sorry,
Sorry, my lord.
on 325.
Yeah. 325 continues the
Point
jurisdiction.
yeah, 0.82.
Sorry, my lord.
I'm just focusing on paragraph 8.2.
Yes, exactly.
Which is
yes.
right.
So that was the point which they took. So that was cards on the table at the start of the adjudication.
Yes.
The adjudicator said no, he did have jurisdiction, and so it went on.
Yes.
But that obviously then entitled simply to take the point on enforcement, because they had reserved their position in relation to the nature of the collateral warranty.
Quite right, my lord, yes. Yeah. The decision was unpaid. There were enforcement proceedings brought in the TCC. The hearing was the 1st of July 2021 before Mr Martin Bowdery QC. The judgment was the 27th of July, which is in the court's bundle. In terms of the enforcement hearing, the respondent disputed the Abbey decision as having no jurisdiction because it was not a construction contract. It took an additional point that there was no jurisdiction to award interest in the adjudication. That was rejected. In terms of the Topham decision, it also took a point that there was no jurisdiction to award VAT. That was rejected. The respondent also sought a stay of execution on grounds of a probable inability to pay by my client. On the evidence, that was rejected also. Part of the submissions on the stay of execution was a stated intention by the respondent to commence its own Part 7 proceedings to have this finally determined, the underlying substance. And at tab 5, page 61, for the court's note, paragraphs 43 and 44 of the judgment, page 61. The respondent asserted that it was in the process of obtaining further expert evidence to enable proceedings to be brought. That submission was required because there is a case, Broseley and Prime Asset Management, which seems to suggest that there is the lack of proceedings can be a threshold bar to obtaining a stay of execution.
Which paragraph was that?
This is paragraphs 43 and 44, my lord. The explanation given is cited at paragraph 43. That's at the hearing of the 1st of July. And that was sufficient to satisfy the lower court that the respondents did intend to commence proceedings to seek a final determination. No such proceedings or any further correspondence or suggestion of proceedings has followed as a result of that. So, my lord, with that context in mind, there is no dispute that the content of the obligations in the warranty is capable of exposing the respondent to liability. And that whether or not this contract is a construction contract has no bearing on the substantive liability of the respondent. The dispute is far narrower and of a much more technical nature, namely the availability of the remedy of adjudication. And it concerns the availability of adjudication as a dispute resolution mechanism for resolving the dispute with, we say, all the benefits of the speed and the cost efficiency and the time saving that affords. So with that context in mind, I turn now to the Act under Part 3 of my submissions. Could I take the court, please, to the authorities bundle, tab 1. Section 104 defines construction contracts. Part 2 of the Act only applies to construction contracts as defined. Section 104.1 provides that a construction contract means an agreement with a person for the carrying out of construction operations, arranging for the carrying out of construction operations, providing its own labour. Section 104.2, which I'll come onto in further detail, clarifies that references in this part include an agreement to do architectural design or surveying work, or providing advice, decoration, or landscaping in relation to construction operations. Section 104.3 excludes employment contracts from the scope of the Act. 104.4 makes provision for statutory instruments to be brought into operation. Section 104.5 provides that where an agreement relates to construction operations and other matters, Part 2 of the Act applies to it so far as it relates to construction operations. And it goes on to say, an agreement relates to construction operations so far as it makes provision of any kind within subsection 1 or 2. My Lord, 2 pages over is...
Hang on a minute.
Yes, my Lord.
So 5 is dealing with hybrids.
Principally hybrid contracts, yes.
Yeah.
And I'll come on to...
But notwithstanding that, it has that additional sentence you've just drawn our attention to.
Yes, and I'll come on to that in further detail, my Lord.
Okay. Yep.
Section 105, 2 pages over, page 5. This is the meaning of construction operations. And the court will see section 105.1 on page 5.
Does section 105 matter for this appeal? Because
Lord, I raise it because
the works are, it's agreed, I think it's common ground that the construction of the care home was a construction operation.
Lord, yes.
So that the works that simply carried out were construction operations. The question is whether the warranty is a construction contract.
It's all about the word for, isn't it?
Well, Lord, yes, it is. And to answer my Lord Justice Coulson's question, I raise section 105 because the court has to deal with, on the narrow issue, a contractual interpretation issue, but also a statutory interpretation issue on the broader ground of whether collateral warranties are within section 104. I draw attention to 105 because the way this is set out is starkly different to 104. 104 provides a very broad, inclusive test, whereas 105 is drawn completely differently. 105 has a specified list of included activities at 105.1. And at 105.2 it has a specified list of excluded activities.
What's the point?
Well, my Lord, the point is on section 104, it is drawn in the very widest of terms. The way it is set out is inclusionary, save as otherwise excluded, as opposed to section 105, which approaches it from the other way, namely with specified exclusions.
Well, surely you just read 105, 1 and 2 into 104, 1A. In agreement with a person for any of the following: A, the carrying out of those things included in 105.
My Lord, yes. In terms of how Part 2 operates, though, it is noteworthy, the appellant submits, that section 104 is drawn in an inclusive way and does not approach whether a matter is a construction contract or not in the same fashion that section 105 deals with operations.
Yes, I understand that point as far as it goes, but 104 is just drafted as it's drafted. It's drafted in a neutral, flat way. I'm not sure you're making much headway with the idea that it has some special quality to it. And as my Lord says, it's a question of whether the agreement is for the carrying out of construction.
Lord, yes. Could I deal with the preliminary point on section 104? A central tenet of the respondent's case is that for the collateral warranty to be a construction contract, it must make provision not only for the carrying out of works, but that the counterparty pays the substantial contract price in respect of that. The preliminary point to be made is that section 104 is not defined by reference to payment or remuneration, and it's concerned purely with functions.
But that's unreal, isn't it? I mean, I know it doesn't, but anybody, I don't have the same length of experience as my Lord Justice Coulson, but anybody who's had to deal with these, the immediate reaction is construction operations are going to involve a contract, which is going to involve payment. I mean, if you decide to build a care centre for free, I suppose that might be okay, but How does that help you?
It helps us, my lord, because Section 104 does not provide for there to be payment in return, as the respondents submit. I accept that commercially there tends to be services provided for exchange of remuneration, but that's not how all construction contracts are set up. There may be multiple agreements where a third party is paying for the works, and strictly the substantial or insubstantial nature of the consideration is irrelevant. What Section 104 is concerned
The fact you paid £1 has got nothing to do with it.
Quite. If it's an agreement legally enforceable, so a deed for free or £1, as in this case, which is adequate and sufficient consideration, it's got nothing to do with the point.
But it's going to be an agreement with consideration.
Yeah, there has to be an agreement, Lord. Yes, it has to have consideration, yes. But once you have an agreement, you are within the scope of 104, and the question is it an agreement for the carrying out of operations?
Right, you're trying to counter the argument that this doesn't look like a construction contract because you didn't pay a large amount of money
Yes.
for a building.
Yes. But that routinely happens, even on what one may describe neutrally as more conventional construction contracts, where a party is to complete works, but there is a funding agreement or other agreement in place, a third-party agreement, which provides this substantial remuneration. It's not relevant to my Lord's consideration today, and it certainly isn't the test for whether there is, quotes, a true construction contract, as the respondent would put it. That would be to devoid 104 of the breadth of its...
There's no such thing as a true construction contract.
Yes.
You just look at the contract. And 20 years ago, they were called building contracts. And snobbery dictated that you now call them construction contracts, but they're still the same thing.
Yeah.
There's no such thing as a true construction contract. You always end up looking at the contract that you have to construe. And anyway, your point is on this, in relation to Section 104, it overcomplicates or potentially overcomplicates it by looking at questions of payment.
Yes, that's quite right, my Lord. There is another point between the parties. So that's the payment point, in order for there to be, quotes, a true construction contract. My Lord Justice Coulson's dealt with that.
Yeah.
There is a further point between the parties, namely whether the Act and Section 104 permits the existence of more than one construction contract in respect of the same relevant works. And similarly, whether the Act requires identification by the court of the one construction contract under which the works are carried out. This is a point raised by the respondents. The references for the court's note are paragraphs 94 and 97 of the respondent's skeleton, and paragraphs 77 and 112, where at 112 the respondent suggests, quote, there can only be one underlying building contract under which the relevant works are carried out. This point, my Lord, I'll deal with it now. This point goes to the point we've just dealt with, but also it informs the word for the carrying out of operations. We respectfully disagree with the respondent's submission. What is required under 104.1 is an agreement. So provided there is a contract for the carrying out of works, the Act does not limit the number of construction contracts to which particular works may be subject. Section 104 doesn't require the Court of Appeal, let alone project managers and parties and lay parties, to ascertain whether there is one particular construction contract and determining whether the works are carried out under that one contract. That overcomplicates, again, what is a relatively straightforward provision in Section 104.
Well, it would spell disaster for the subcontracting industry, wouldn't it?
Yes.
Because if the piling works are part of the main contract, but they're also part of the subcontract, they would be the subject of two different construction contracts.
Quite. That was the example I was going to give, main contracts, subcontract, but there are other examples as well. It's not uncommon for contractors to enter into two or more contracts with different counterparties if there are joint employers, but which employers are separate from a corporate entity perspective. Similarly, it's not uncommon for there to be a contract for the supply of goods and equipment on the one hand, and a second contract for the execution of physical operations with express terms under both of those contracts to carry out and complete the whole of the project works. So it is a feature of collateral warranties, and it is a feature of this warranty, that the contractor is already under an obligation under the building contract to do works. That doesn't inform or assist the respondent. It's irrelevant to the test under Section 104, and Section 104 is not limited to cases where there are new provisions to carry out operations. That point is dealt with in an early case called Yarm Road, which is at tab 6 of the authorities bundle. At tab 6, page 91. It was intended in the context of a novation agreement that there had to be, as it were, new provisions for construction operations in addition to the underlying building contract. And that is apparent from the second paragraph beginning Mr John Martin QC submitted.
Sorry, page?
Page 91 on tab 6.
New provision, new over and above what?
Over and above an existing construction contract. So here this was a novation agreement. There was a pre-existing subcontract. The novation agreement novated the subcontract to a fresh party. Right. It was contended that the novation agreement was not a construction contract giving rise to a right of adjudication, because the Act required under Section 104, it was suggested, new provisions. That was rejected by the court. There was a right of adjudication under the novation agreement. And tab page 94.
Did you need it? Once the contract's been novated, why haven't you just got a construction contract under the original contract?
My lord.
What am I misunderstanding?
Well, there are two aspects there. The first is page 89. The novation agreement was expressed. This is in the middle. It is expressed at page 89. The novation agreement was expressed to be supplemental to the subcontract.
Yep.
And the second point is that it was suggested that as a matter of law, the effect of the novation agreement was to extinguish the original subcontract and replace it. So there's 2 points. But the court dealt with both, and it rejected that assertion. At page 94, the court found it's the middle of the page, I accept that, page 94. The court found that it is not open to construe Section 104 in that way, and further that Section 104 was, quotes, clear. The novation agreement fell within 104. There was a right to adjudication, even though there were no express terms in the novation agreement for adjudication.
That covers Topham's position in this case. Is it?
Well, Topham were novating, my lord, yes. They also had...
Yes, so that's... Well, they didn't have that problem.
Yes. My lord, on a related point, we've been covering whether or not the contract requires there to be reciprocal payment for the works. Mm-hmm. And it is suggested, the court's note at paragraph 88 of the respondent skeleton, that there is a risk of liability on the beneficiary to have to pay for the substantive contract price under the building contract. And similarly, at paragraph 110, that point is taken. The respondent asserts that there's no sound basis for the warranty, quote, that it should impose on Abbey the same obligations in respect of payment of the works. We would respectfully suggest that that confuses the position. Neither the collateral warranty or the Act impose any obligation on Abbey to pay the contract price under a separate contract. The arrangement is far more commercially valuable. It's effectively one way. It gives Abbey the rights, but not the obligations. A similar point is taken by the respondent about the implication of rights of termination or ordering of variations or rights in respect to the progress of the work. It's not a legitimate concern. It simply does not arise. It's not mandated.
I'm not quite understanding how all this got to do with whether something's a construction contract or not.
Well, this is suggested in the context by the respondent as to how they say Section 104 should be interpreted.
So they say one of the points is that there has to be a risk
Yes.
on the beneficiary, that's Abbey in this case, for to make payment. And you say no, under the terms of the collateral warranty, it's just one way.
Yes, quite right, my lord. And
Yeah.
that's part of the respondent's overall position as to what they call the true construction contract, and there being only one contract. And we say all of that is respectfully wrong, and it's not based on Section 104. So those are the appellant's submissions, my lord, on whether the Act permits or requires only one construction contract. There's no basis for that. Just moving on to a further issue, insofar as it's suggested that the Act applies to obligations to carry out work in the future only, that submission is to be rejected as well. Many construction contracts are formed or entered into after work has commenced, or indeed long after the works have been completed, with the parties implicitly or expressly intending that the contract will operate to govern that past performance. They are, as I've said, continuing obligations, and to carry out these works during the life of the project, and that's essential to the limitation period, which accrues up to practical completion. The point taken by the respondent on this, the retroactivity nature, is that the respondent suggests there's a material difference between a building contract and a collateral warranty, in that there will invariably be a prior relationship, the respondent says, when it comes to there being a building contract, whereas that's not typically the case with the collateral warranty. Again, we would dispute that premise, not just in principle, but on the facts. Here, the construction contract makes careful reference, as I'll come on to the categories of beneficiary to which these warranties are to be provided. Top-an, also the tenant, the management company. It's not necessary for there to be a pre-existing relationship. And for the court's note, if I could take the court briefly, please, to tab 8 of the authorities bundle. Page 123.
One, two, three.
Yes, please, my lord.
In
the authorities bundle, please, tab 8. This is the case of Northern and Shell, the leading authority on the retroactive nature of obligations in construction contracts. It was suggested, and this is set out in paragraph 53, that for a clause to have retroactive effect, that could only be the case where there was a pre-existing relationship, and the court rejected that. Indeed, I think it was ultimately conceded at the appeal in oral submission. So with that in mind, my lord, the brief point is it cannot be said in a contract with retroactive obligations, as we have here under the warranty, that the Act only governs any outstanding element of work to be completed.
How common are these warranties in practice?
Extremely common, my lord. In a typical design and build contract such as this, there'll be a contract to design and build an asset, a care home. There will then be numerous parties who then use that asset: the freeholder, the management company, the tenant. In most large or sophisticated contracts, there are provisions under the building contract for collateral warranties.
And this is standard form.
There are few standard forms. This is not relevant to my lord's consideration, but my experience is that typically, or almost invariably, these warranties do not contain express provisions for adjudication. Lord, the final point on 104, if I could take the court back, please, to tab 1, which has section 104 of the authority. Just closing off the point as to the Act only covering future works, but we say that's not right. Insofar as reliance is placed on section 104.2, this provides that references to a construction contract include an agreement to do design or surveying work or the like. At first blush, that might suggest that to fall within section 104.2, the agreement must require the professional or the contractor to do something in the future. But that literal interpretation does not meet the situation, whereas here there is an agreement governing services already performed, or where the obligations are retroactive in effect. What section 104 is doing my lords, is merely clarifying the breadth of section 104 as encompassing incidental services such as surveying work or decorating consequent upon construction operations. Once it is acknowledged that the Act must apply to all of the obligations in a construction contract, consisting of both past performance and future performance, the Act must similarly apply to a collateral warranty to both natures of those obligations in the form here. My lord, those are my submissions on section 104. I'd turn very briefly now to section 108. This is at page 11. Section 108, my lords, is the statutory right of adjudication. So where there is a construction contract, and if there are no express terms providing for adjudication, section 108 imports the regime of adjudication by way of a contractual implied term into the construction contract. And indeed, there is a requirement under statute, section 108.2, as to what each construction contract shall contain, as to giving notices for carrying out an adjudication and the time limit and how it should take place. And to the extent that those provisions are not contained in the contract, then section 108.5 at the bottom of the page provides that a set of terms are imported by implied term under the scheme, the 1998 scheme. The key points to note here on section 108 is that...
And this adjudication was in accordance with the scheme?
Correct, my lord, yes.
Because there were no terms in the warranty dealing with adjudication?
Yes, my lord.
Yeah.
Yes, thank you. The point to note is, again, the breadth of 108. It's any dispute arising under the contract. That has been interpreted by the TCC in a broad and an encompassing fashion. The breadth and availability of section 108 is frequently utilised by parties in respect of fire safety defects, such as cases like this, especially post-Grenfell and in other disputes. Adjudication offers many attractions and benefits to parties. It's relatively cheap compared with high court litigation. It gives the ability to commence an adjudication at any time. It takes place over a very short period, 28 days, and there's no cost liability. There's no risk for paying the other side's costs because each party bears their own costs, save for a contrary position.
Would it be right to say that adjudication has as one of the paradigms the sort of in operations model, namely that these sort of timescales are particularly appropriate for disputes arising during the course of operations?
My lord, that's the point that's taken by the respondent. It's certainly a feature, I accept, that one of the reasons behind Part 2 of the Act was to improve cash flow on live projects and so that these disputes can be resolved quickly. But that's obviously by no means the end of the matter. Frequently, and particularly in larger projects, and invariably on latent defects cases, i.e. defects which were not apparent as at PC but nevertheless are existing, there are many disputes which are dealt with by adjudication post-completion. So the court shouldn't place weight over one type of dispute or the other, and certainly the Act in section 104 and 108 do not make that distinction. My lord, sections 109 and 113 concern payments. I'll deal with them briefly, because a point is taken by the respondents as to whether, well, this warranty can't make sense, they say, because you would have to have the implied terms as to payment under the Act, and that wouldn't work in this case. I'll deal with that now. Section 109, my lords, is at page 14. It provides that a party to a construction contract is entitled to payment by instalments, stage payments, or other periodic payments for any work under the contract, unless it is specified in the contract that the duration of the works is less than 45 days. And then section 109.2 goes on to provide that the parties are free to agree the amounts of the payments, the intervals at which, or circumstances in which they become due. That is an important provision because here it is perfectly permissible, as with this warranty, for the parties to agree a nominal consideration of £1, which is paid in advance, and as such the parties have agreed the circumstances in which the payment is due. So there is no need to import any terms under the scheme dealing with payment because the parties have dealt with it and it complies with the requirements under the Act. So there is no tension between the minimum terms required under construction contracts for Section 109 onwards, with collateral warranties generally being construction contracts. I should add that we accept that almost invariably these collateral warranties either have are executed as deeds with no formal consideration, or they have a £1 or a nominal or a token consideration. For the reasons I've given, that's not relevant, and it's not right, as the respondent said, to suggest that this will give rise to all sorts of difficulties. On the contrary, Section 109(2) caters for that. Well, those are the appellant submissions on the Act and its interpretation. I'll turn now to Part 3, which is the building contract and the warranty. The building contract is at tab 12 of the main bundle.
I think it was your Part 4.
My lord, it is Part 4. I'm so sorry.
Yeah, that's right.
Thank you. The building contract was between, as I've said, Sapphire as employer and simply as contractor. It incorporates the JCT Designer Bill 2011 form, which is a standard form. If I could take the court, please, to page 152. 152, 152, please, my lord.
Thank you.
Clause 2.1 provides that the contractor shall carry out and complete the works in a proper and workmanlike manner and in compliance with the contract documents and shall complete the design. At page 160, clause 2.35 concerns the remediation of defects. And specifically defects which appear within the defects liability period, which is typically a period of 6 months or a year or 2 years, depending on what the parties have agreed, after practical completion. I should add, at common law, and absent any term to the contrary, the obligation to carry out and complete the works that we saw at clause 2 includes the remediation of existing defective works and any cause of action for breach, and that accrues up to practical completion. So there's an ongoing obligation in carrying out and completing the works to remedy any defects. In terms of authority, I rely on the Swansea decision at tab 5 of the authorities bundle, page 84, which cites the well-known decision of Oxford Architects and Cheltenham Ladies. I don't propose to take the court to it, but it's there for the court's note.
What was the paragraph in Swansea?
Yes, paragraph 57 in Swansea, page 84 of the authorities bundle, citing Mr Justice Ramsey in Oxford Architects and Cheltenham Ladies. Mm-hmm. The JCT 2011 Design and Build makes provision for collateral warranties. So if I could deal with the preliminaries first, at page 147, there is a list of definitions under the contract. And the court will see at page 147, about halfway down, P&T rights. That stands for purchaser and tenant rights. And it's defined as the rights in favour of a purchaser or a tenant set out in Part 1 of Schedule 5 or in the appropriate form of collateral warranty. Schedule 5, which we'll come to, is the standard form of the warranty annexed to the building contract. Purchaser and tenant are defined over the page 148. Purchaser is any person named or otherwise sufficiently identified as such, whether by class or description, in or by the P&T rights particulars, to whom the employer transfers or agrees to transfer his interest in all or part of the works. And tenant is similarly defined, but in respect of a leasehold interest. The building contract provides detailed and bespoke terms for the provision of warranties. So page 187, please, 187. Clause 7C of the standard form 2011 JCT, there is provision where the P&T rights engage, which is this contract, within 14 days of a notice to enter into a warranty. That's what the contractor has to do. The form of that warranty has been slightly amended, and one sees that at page 263. So for the court's note, it's 263. It amends ever so slightly clause 7C.
263.
Yes. To refer to the form at Schedule 5.
Do you want us to look at it now?
Well, you don't need to. It just amends the last line and it refers to Schedule 5. The point is these are amended terms with, we say, some careful consideration. The amendments specifically have Topan in mind as the purchaser, but they also have the future leasehold tenant in mind. So I would draw attention to Article 20 of the amendments. This is at page 243. There is reference in respect of payments to the existence and the future interest of Topan.
Article 20.
Yes. And then further it's 246. Has a category of beneficiaries to whom these warranties will be provided under clause 7C. Again, this is a bespoke amendment. Any purchaser is defined, Topan and the management company being the tenant, which is Abbey.
Sorry, say that again. Page 246, there's a reference to the management company.
Yes, my lord.
Yeah, and what did you say about that?
Yes, the management company is Abbey, the tenant. So it's within the closed category of beneficiaries, which are named by class in the amendments to the contract at page 246.
And is management company defined? You gave us the definition of purchaser and tenant.
Forgive me, where does it refer to management contract on 246?
Management company.
Management company, my lord. It's the bottom.
Name, class, or description of person?
Yes. My lord,
Am I looking at the right page? 246
Yes.
starts part 2, collateral warranties.
Yes.
10 lines down.
There is then a matrix, my lord, in the middle with 3 categories of beneficiaries for the warranty.
Okay, got it.
So any future purchaser, Topan, and then the management.
Sorry, it was staring me in the face.
Sorry, my lord. Management company is not defined, my lord. It's not in the list of.
Okay, but you say that's Abbey.
As a matter of fact, it's Abbey, and that's the basis on which it was ultimately provided when the Part 8 proceedings were commenced. Yes.
Yeah.
My lord, the form of the warranty is at Schedule 5. This is at 271. And if the court goes to 274, this is in materially the same terms as the Abbey warranty and the Topan warranty. I highlight the point I raised earlier. There is some oddity with the numbering, as you'll see. It's gone slightly awry, but that is corrected in the final versions. It goes 2, 3, 4, 5, 6, 7, 3, and then over the page you'll see the same problem with the numbering.
Hang on, so 271, this is Schedule 5. So this is the warranty as per the contract.
Yes, my lord, the standard form, yes.
Yeah. Yeah.
The respondent urges particular emphasis to be placed in this case on what it calls factual context, and it places weight again, as we've said, on the timing of the warranty and the lack of express terms providing for adjudication. Of course, part of the context is that this particular warranty, as is often, if not invariably the case, it is fixed at the outset in the building contract in a bespoke form. So insofar as context is relevant, and we would obviously be focusing on the express words, the key point is that simply, as the contractor, the respondent, agreed at the outset in the building contract to provide warranties in precisely the same terms with, we say, equivalent packages of rights to specific classes of beneficiary.
Right, so you say that would support the idea that the package of rights that was owed to somebody who indubitably had adjudication rights, and then that package of rights is then mapped across to the management company, the tenant, in this case speaks for that package of rights, also including the right to adjudicate.
Quite right, my lord. So in this case, what we saw was that Topan, the freeholder who was in existence, received its warranty relatively early during the works, and there's no dispute between the parties that that warranty is a construction contract. It's in the same terms. It's signed before practical completion with works in fact still to be carried out. That is a construction contract. The same terms on a later warranty, the Abbey warranty, is the opposite. It's not a construction contract based on the time it's signed. And we say the importance of the equivalent package of rights is that there are specific and quite narrow classes of beneficiary which are named Topan, future purchaser, future tenant or management company.
Right.
It must be the intention to have the same rights.
I may have lost my focus, but is it part of your argument that if the respondent to this appeal is right about your warranty not qualifying, then Topan shouldn't have qualified either? I mean, I know you don't have to argue that, but...
No, I wouldn't argue that. I would be arguing the obverse, yes.
Well, I understand you're arguing the others, but if they're right, then, and the timing point is not material,
yes,
then it would follow that Topan should have lost as well.
But, my lord, the Topan adjudication was pursued under the building contract.
I see.
Yes.
But the Topan wouldn't have had any rights under 104, because if you're right about the timing point, there'd be no reason to discriminate between Topan and Abbey.
My lord, I think that must follow, yes, because when one looks, if one's looking at the substance of the warranty, and if my lords were to find that this is just a product warranty for a state of affairs, then logically I think if timing goes out the window, that would apply equally to Topan and Abbey, yes. Yes.
But that would simply be highlighting the difference between a novation and what you're calling a product warranty.
My lord, sorry, could my lord put that in different
Well,
terms?
you recognise that after the novation there is undoubtedly a right to adjudicate under the building contract.
Yes.
And what I was groping after was if the warranty is to be characterised in the term you used as a product warranty simply, then that's just an indication of one of the differences between a novation and a product warranty.
My lord, the key difference I think being that, well, we're suggesting that there shouldn't really be a difference because under the novation it's a short document which transposes rights and obligations to perform under the building contract. And similarly, the collateral warranty is phrased in terms of carrying out and performing obligations under the building contract. So they are, in effect, similar in type and in nature, the obligations. So that's how we would put that position. One can't pin one's colours to the mast on timing. That's for sure.
No, that's a separate point.
Yes, but in any event, the obverse of that raises an issue because there has been no dispute before the judge or below that the Topan warranty would be a construction contract based on the timing point, working in Topan's favour. Whereas on this reasoning, the same terms as I've said would not be a warranty. We say that can't have been the party's intention.
And the objection to jurisdiction was raised only in relation to Abbey, not in relation to Topan, is that right?
Correct, yes, but I do repeat that the Topan adjudication was under the building contract.
Yes, all right.
Yeah, they didn't take a similar point in respect of the novation agreement, is how one could put it. But logically, could they have done? Yes. So that's the position, my lord, and clearly we say it makes sense commercially where these form of warranties are being agreed at the outset for everyone to have the same equivalent package of rights. And on our case, that is an inclusive approach, namely every party, no matter when it was executed.
So you argue for equivalent terms, equivalent remedies?
Yes. Yes, my lord. My lord, in support of that, or further to it, there is no time limit in the building contract for when these warranties could be demanded. That the court will have in mind it's an obligation to provide the warranty within 14 days of notice. So that could be at the start, or the middle, or the end, or 11 years after. Topan was in existence, and its precise identity was known at the time of the building contract. It got its warranty early. Conversely, Abbey was not, but it was obviously recognised as being within the class of beneficiaries who was to obtain that warranty.
But the fact that you only came into existence at a certain time in this case is a red herring, isn't it? I mean, it doesn't matter. I mean, you were just an unidentified at the time tenant.
Quite. It's only relevant if the court were to uphold the timing point, where it would become a point against the timing point, effectively. It shows why the timing point it operates arbitrarily and unfairly. My lord, of course, the building contract provided a right of adjudication in clause 9.2. For the court's note, that's at page 194. And if I could turn now to the collateral warranty itself that was executed, starting at page 293, tab 13.
I can't remember. Is this number 5 or is this the continuation?
No,
of the
this is
building
It's
contract?
4.2.
Yes.
You're
4.1 was the building contract.
tendentiously
4.2.
building it into your submissions on the building contract.
No, but in fairness, my lord, building contract and collateral warranty.
You did.
So turning, as my Lord Justice Coulson says, 4.2 to the collateral warranty itself, I'd ask the court please to start at 293. This is the provision which sets out the parties and then runs through the recitals. And there's 4 key elements that I would identify about this agreement. First, we see the recitals and the definitions of the instrument. They set up the content of the obligations by reference to the underlying building contract and the carrying out of operations. That can be seen in the recitals by reference to the contract itself, the definition of contract in clause 1, which is the JCT, under which the contractor is to carry out the works and the design of the works. And at the bottom of clause 1, the definition of works means the construction of the development at the site, as more particularly described in the contract. So before one gets to the material terms, the context and the instrument is set up by reference to, we say, the carrying out of operations and the operations themselves. So secondly, in light of that framework, if we turn over the page to clause 4, there are detailed terms in clause 4 as to the carrying out of construction operations.
Is this your second of 4 elements?
Yes, my lord, yes. So first is
First is clause 1, second is
clause 1,
4.
recitals and definitions, setting up the context
Yes.
of these obligations by reference to operations themselves.
Back to
2
clause 4.
is clause 4, which is the operative, which is really the key provisions here for the court to construe.
Well, you've taken those already.
Yes, and you've seen them, and you have my point on that. These are framed, we say, as the performance and carrying out of construction operations, past and future, and we place emphasis, or really some emphasis, on the future exercise of those obligations, retroactively incorporated.
Right, you're saying the warranty couldn't get closer to being about building work?
Yes. Yeah,
If
quite.
it tried?
It could be phrased in, if it was a product warranty, we would say that it would be phrased much more simply than this. It wouldn't be over various sub-clauses. It will say the works are of satisfactory quality, full stop. The works have a design life of 10 years, full stop. The works comply with BS 1234, British Standard, whatever it is. It wouldn't be phrased in this much more detailed manner, using the statutory language of carrying out and completing the works.
Why not? What this does is to set up things which, by reference to the building contract, if there's a breach of the building contract, it puts them in breach of the warranty. Full stop. And what they've done is they've tracked the obligations of the contractor under the building contract, so far as it constitutes, or so far as it gives rise to an obligation to exercise due care and skill.
And they're phrased in this way, my lord. If we take 4.1b as an example, the carrying out and completing of the works has exercised and will continue to exercise reasonable skill and care. Take an example of the warrantor not carrying out the works at all, or the warrantor carrying out half of the works, or carrying out the works defectively. We say there is a direct right and remedy under 4.1b, not just in respect of a state of affairs, but in respect of the performance of those obligations. The respondent has to, under the warranty,
You can't get involved with the contract. So, for example, you have no no right to, you don't have a supervising officer, you don't have a right to issue variations, you don't have a right to terminate, you don't have a right to liquidated damages, you don't have a right to anything that can be described as enforcement. What you do have is that if there are breaches of the underlying contract, that puts them in breach of a warranty, which gives you a normal claim for damages if you suffered loss and damage.
We would say that this contract goes further than that, my lord, because there are warranties put in, there are terms put in express fashion as the carrying out of works. So we would respectfully disagree, and we would suggest that were works not to be carried out, that would give a remedy, because the respondent would be in breach of its obligation here under 4.1b to carry out and complete the works.
I think my Lord's question goes to the question of remedy,
Yeah.
which is potentially the critical paragraph in Parkwood,
Yes.
which we'll doubtless come to when we look at Parkwood. But what would be the remedy? Because the beneficiary couldn't get specific performance. I mean, I'm taking your example of the warrantor failing to carry out works.
Yes.
So the warrantor refused to build the east wing. In those circumstances, what would the beneficiaries... The beneficiary would have a claim for breach of warranty, so a damages claim, a claim under the warranty. But it wouldn't be entitled to specific performance of the building contract, would it?
Well, Mr Justice Aikenhead in Parkwood, which we'll come on to, suggests that at least in principle, on clauses which provide for the future carrying out of work, so carrying out and completing works, that in principle that such a remedy would be available to the beneficiary. Of course, there would be all the problems of that being an equitable remedy and the difficulties of obtaining that order, but at least as a matter of principle, that would be available. So we say that remedies here are important because they are available in principle, and one derives that from how these clauses are phrased. I'll develop that further when we look at Parkwood, but Mr Justice Aikenhead deals with that and suggests that that would be the case on terms similar or equivalent to this. Well, putting it another way, if we swapped the order of the wording in 4.1b, so that it started with exercise the reasonable skill and care diligence in carrying out and completing the works, what 4.1b is doing, and similarly 4.1a, it's a promise that those works will be carried out and that they will be completed, past and future, and that they give rise to remedies as a result. So my third and fourth points, which I think we've dealt with, the third point was this cannot be read as a product warranty. It's far too involved and detailed by reference to the wording of section 104 to be read down as a mere warranty of a state of affairs. And the fourth point was that it does give rise to the contractual remedies that would arise in respect of construction operations themselves. My lord, the respondent's case...
Sorry, is it your... I'm still not quite clear. Is it your submission that the effect of this is that you can intervene in the contract other than by step-in, which is provided for 7/7,
Yeah.
which is different?
Well, step-in provides a right by reference to this collateral warranty to step in the event of insolvency. Yes.
Yes, but that's the only circumstance under this warranty. I think we need to be clear about this.
Yeah.
Well, I need to be clear about this. What you're saying. Do you accept that the only circumstances in which you can intervene directly in the administration and enforcement of the contract is by step-in?
My lord, no, we wouldn't accept that. Under 4.1, what we would say is that there is a right under the warranty for the carrying out of operations. So to the extent that those obligations are breached, there are in principle remedies under the warranty to resolve that. Not necessarily getting involved in the building contract itself, but remedies which arise on the face of this separate agreement.
Well, the remedy is damages. The only remedy you have, however we interpret it, surely, the only remedy you have under paragraph 4 is an action for damages, for breach of warranty.
My lord, no, we wouldn't accept that. I mean,
so what
under a building contract, so under the building contract itself, as a matter of practicality, the remedy is damages, and that specific performance is not typically a remedy sought or awarded. In principle, it's available. We say here, although as a matter of practicality, specific performance would be very difficult, if not impossible, on certain facts, it is nevertheless available. So to answer the question by reference to remedy would put the appellant's position at a great disadvantage. It assumes that there is not equivalence in terms of actionability for breach of clause 4.1 as there would be under the building contract. What we say is 4.1b gives you the remedy for damages, but it also gives you whatever other contractual or equitable remedies you might seek to enforce. Similarly, the position is the same under the building contract, but of course the practical starting point under both is that obtaining specific performance or injunctive relief is typically going to be very difficult.
Let's take a trite example. Forget warranties and just speak about a building contract. That if the particular contractor had a particular specialist type of chimney pot or flue or something like this that nobody else had, and they left it off, and they were challenged about that, you say that in principle there's no reason why they can't be ordered to put that chimney pot or flue on the building.
Well, Lord, yes, because what's happened by virtue of the warranty is that same contractor...
Well, I'm not talking about the warranty. I'm just starting with the building contract. Of course, typically, I suppose, damages are the answer, because
yes.
things have reached the stage where you're not going to get people back to do things that you can get other people to do better.
Yes.
But in principle, let's suppose there was some particular piece of kit that the contractor had that you had bargained for, then there's no reason why they can't be ordered to put it on.
Well, there's no reason in principle law, but the case law is pretty clear on that. When it comes to requiring construction contractors to undertake works which involve personal service, people going to site and doing things, that it's very rarely, if ever, ordered. So what we say is that in practice, this just doesn't arise under the building contract or under the warranty, but as a matter of principle at least, it is capable of being there and enforceable on both, because under clause 4 of this warranty, you have that direct promise between the contractor.
Right. But you say questions of whether or not specific performance would be ordered doesn't help one in interpreting whether this is a construction contract or not.
No, quite right, because we start 10 metres behind the start line, as it were, because as a matter of practicality,
it wouldn't be ordered even in the main contract.
Sorry. It's always dangerous to argue by reference to what people could have said.
Yes.
But if you're right, why doesn't this say the contractor agrees that the contractor has performed and will perform, or it's easier in 4.1b that he will carry out and complete the works and will exercise. So why isn't it expressed in a normal way of a bilateral obligation? Or do you just say it is?
Well, my lord, yeah, this is expressed, I think, in terms of the appellant's case, to take 4.1a, has performed and will continue to perform the obligations, and in 4.1b, in carrying out and completing, has exercised and will continue to exercise. So it's put very widely in favour of my clients as to what it's done and what it's going to do, and by reference to the carrying out of operations. And what we have in clause 2.1 of the building contract, as the court may recall, the contractor shall carry out and complete the works in a proper and workmanlike manner. If anything, this warranty goes a little further than the building contract. In carrying out and completing the works, it has exercised and will continue exercising the standard required under this contract, or it has performed and will continue to perform. And we do place emphasis on the future obligations here, my lord. I agree that we would be in a much trickier position if this warranty simply said the contractor has performed in accordance with its obligations, or the contractor has exercised skill. It doesn't say that. It has that important prospective and future element enforceable from the outset due to the retroactivity. And this is a point which was brought before the court at first instance. So at first instance, the respondent's position below was that these wordings as to future performance, it said in terms that they were just redundant. You were to give no effect to them. Its case on appeal has become slightly more nuanced, and for the court's reference, it's paragraphs 49 to 54 of the respondent's skeleton. What the respondent says is the respondent was not, quote, thereby committing or assuming any obligation to carry out and complete the works. So it's gone from saying at first instance the future part of the obligation is redundant, you just don't pay effect to it because of the timing point. It's now moved to a position of saying that, okay, those words are there and you have to construe them, but the respondent was not committing or assuming any obligation to carry out works. It then gives an analogy. It suggests this analogy, quote, in running for president, I promise to act with integrity. That's the analogy given in the skeleton. In running for president, I promise to act with integrity. The respondent suggests that that's not a promise to run for president, but a promise to act with integrity in the event that they do so. And what we would say about that is it's not a particularly helpful analogy, but it rather reinforces our point, because under the building contract and the collateral warranty, works, as a matter of fact, are being undertaken.
Yes, right. And you say they were running for president.
Yes, they were on the ballot paper in the race. They were running.
Yes.
It's not a conditional obligation as they would now.
We'll see whether that image is pushed later.
Yes.
All right.
The point is important, though. These future elements of the obligations provided are of significance. They can't be ignored, and they can't be characterised now as a conditional or an if obligation. My Lord, just turning back to some of the further features of this warranty, clause 4.2 underlines and reinforces the significance of the respondent's obligation to carry out construction works. Because what 4.2 does is it deems the respondent's obligations and liabilities under the warranty to take effect in all respects as if the building contract had been dated prior to the performance of any works. In other words, the parties there have agreed in terms that there is retroactivity, and that's important for two reasons.
It's the timing point.
Yes, it's the timing point, but it does raise an important practical point for both sides. For the warrantor, it gives certainty on the limitation period. It has a 12-year period from practical completion. And similarly, for the beneficiary, it gives certainty on the cause of action in respect of the carrying out of works, regardless of when the warranty was entered into. And that point is an important point, recognised by the Court of Appeal in Northern and Shell. It's at tab 8 of the authorities bundle. To the court note, page 122.
So this gives certainty about the cause of action.
Yes, so for the warrantor, it gives certainty on the limitation period for which they will or may be exposed. That's the warrantor. And for the beneficiary, it gives certainty on there being a cause of action in respect of the carrying out of works, regardless of when those works were undertaken, and regardless of when the warranty was entered into.
Yes, page...
yes, it's page 122, my Lord. It's paragraph 50. And the second half of that paragraph deals with the importance of those future provisions and retroactivity, giving certainty to both parties. Well, Lord, in terms of clause 4.3, so that's 4.2. 4.3 is a provision which states that the contractor shall owe no greater duties to the beneficiary under this agreement than it would had the beneficiary been named as the employer under the building contract. we say that here 4.3 is confirming the imposition of equivalence duties on the respondent under the collateral warranty as it has under the building contract. It's giving parity to the beneficiary of the rights that it enjoys. On the question of contractual interpretation, it also shows the inherent link that there is between the building contract and the collateral warranty, which is parasitic upon that building contract, and how the two have to be construed together accordingly. In support of that, we would also rely on clause 13, which confirms the same 12-year limitation period. This is at page 297, clause 13. When the court exercises its function of interpretation, it's required to check by an iterative approach as to consistency with either party's submissions with commercial sense, and checking the parties' rival interpretations in this case. The consequences of the respondent's submissions would be as follows. First, there would be an inconsistency in the unitary exercise of interpretation itself. We dealt with this a little earlier. The point is the inconsistency of approach when looking at the retroactivity point, where timing is irrelevant, compared with looking at the substance of this warranty and whether it's within section 104. The same exercise of construction should not yield inconsistent or different approaches. Secondly, inconsistencies...
That's the timing point.
Yes.
I mean, that in a sentence is your answer to the judge. That can't be right, because if we'd entered into it earlier, it would be a construction contract. So the same terms can't give rise to a completely different outcome because of the date on which it was entered into.
Yes, and that's not merely a theoretical point, my Lord. It's what happened in this case, as we've seen. The Topham warranty was before completion, the Abbey warranty was after.
Yeah.
The second point, inconsistency within the terms of the collateral warranty itself. At clause 9 of the warranty, this is at page 296.
Yeah.
In addition to the obligation under the building contract 7C to provide warranties, clause 9 vests a right in the beneficiary of this warranty to require the respondent to execute further collateral warranties, and that's a direct right under clause 9. The warranty which is to be provided is again in the same form as that in the building contract.
Who was trying to sell? Was it Topham or Abbey?
Topham, the freeholder, was trying to sell, yes. And we say it's inherently improbable, therefore, that the parties intended different rights and remedies to flow, again, depending on the time of signature. Finally...
But what circumstance would 9 come into effect? If Abbey divested itself of its business and was selling its business to somebody else?
Yeah.
Is that what's involved there?
Or if there was then a first purchaser, exactly, my Lord, yeah. So there's a first purchaser. So in the event that Topham sold the business, can Abbey then, it has a right under this warranty, under clause 9, to require simply to provide a warranty to the first purchaser. And it just can't be intended that, depending on the timing point again, which of course heard loud and clear, these should be any different in substance. And finally, commercial uncertainty and further unintended practical consequences. For example, the approach of the lower court and of the respondent will lead to factual inquiries and disputes as to what works were completed and to what extent at the date of the physical execution of the warranty, and which particular operations, if any, are capable of being referable to adjudication. That is exacerbated in the not uncommon position that there is a dispute as to whether practical completion was achieved at all or when it was achieved, or if it's a milestone contract where payment and obligations to do sections or packages of work, whether they've been done or not by the time of execution. There are further practical problems, my lord, which the parties just could not have intended on the lower court's interpretation. For example, in the event of insolvency, the judgment and the respondent's position makes it far more difficult now, from a commercial perspective, to procure warranties on live projects and to restructure them in the event of an insolvency. There's no impetus, or rather, putting it the other way, there is every impetus for a warrantor to hold back or delay or simply not provide a warranty when it is meant to. That's obviously contrary to the purpose and breadth of the Act and the value, the inherent value in these warranties. Particularly on an insolvency case where this project needs to be got up and running again, and where there may be disputes which need to be resolved promptly, i.e. to minimise disruption and to adjudicate quickly and cost effectively. There are other contexts too. Certain contracts provide for collateral warranties only to be given at practical completion. Obviously the court has to construe each contract on its own terms, but we would suggest it's not Parliament's intention in this case or any other, to create, in effect, different classes, different tiers of beneficiaries, which on the lower court's judgment there is. There is what we would categorise as a two-tier system. Well, those are my submissions on the warranty. Turning now, please, to Parkwood, Part 5. The respondent contends that the Court of Appeal should overrule Parkwood as being incorrectly decided. The appellant, we suggest that Parkwood was, with respect, correctly decided.
So we're on the respondent's notice. We're on the respondent's notice.
Yes, my lord, yes. My lord, the case of Parkwood is it's had 4 of the authorities bundle. Lord, facts by way of brief background. Parkwood was the facilities manager at a swimming pool in Cardiff. Cardiff City Council owned the pool. It leased the site to a company called Orion. The pool was constructed for Orion by Lang O'Rourke under a construction contract, a JCT, and the building contract between Lang O'Rourke and Orion, the material term is Article 10, which is page 67. The court sees at the bottom left of the first column, paragraph 4 of the judgment, Article 10, the provision under the building contract for providing warranties to be executed in a specified form. At paragraph 5 of the judgment, we are told that practical completion was in 2008. It's not stated when precisely. Lang O'Rourke provided the warranty to Parkwood before practical completion and on the 6th of December 2007. The terms of the warranty are set out at page 70. And it provides that the contractor warrants, acknowledges, undertakes that it has carried out and shall carry out and complete the works, point 1. And it then deals with the design of the works in point 3, and then materials in point 4. And under point 7 at the top, second column, it says, has complied and will continue to comply with the terms of regularly and diligently carrying out obligations under the contract, so under the building contract. If I could take the court then, please, to page 72. Mr Justice Aiken had considered from paragraph 17 onwards, section 104. So his lordship set out section 104, paragraph 17, section 105 at paragraph 18, and the adjudication provision at section 108 and 19. His lordship confirmed that there's no direct authority as to the extent to which, if at all, collateral warranties are to be considered construction contracts. His lordship said there's little or nothing in the Act other than simply the wording in section 104, which illuminates what an agreement for the carrying out of construction operation means. He says at the bottom of the first column, his lordship says it could be said that the words are unambiguous and therefore there is no need to resort to Hansard. His lordship then considers the difference between section 104.1 and 104.2 at 21. And his lordship finds that section 104.1 is broader than section 104.2, and middle way through paragraph 21, undoubtedly, section 104.1 is drawn very widely, albeit the term construction operations in 105 is more closely defined. Paragraph 22, in my judgment there can be no doubt that the reference to a contract must mean a contract under English law, however formed, simple, in writing, oral, under seal or otherwise.
Can I just sow dragon's tooth? In paragraph 21, would you agree with the statement in Coulson on construction adjudication that the Act applies to all contracts related to, or might that be a fraction too broad?
Well, my lord, it's an interesting point. Section 104 is for the carrying out of construction operation.
Correct.
We also then have under 104.5, which my Lord Justice Coulson alighted to earlier, a slightly wider definition, if I can just remind myself of that. Section 104.5, an agreement relates to construction operations so far as it makes provision of any kind within subsection 1. With the greatest of respect to my Lord Justice Coulson, I don't think I could submit that it means in any way connected to or related to, because I think on a fair reading, section 104.1 is not phrased in that way. It's for the carrying out of operation. But that said, it is plainly right, as Mr Justice Aikenhead has found, that section 104.1 is to have a very broad meaning, and that is reinforced by section 104.5. Paragraph 22, his lordship made the point which we discussed earlier in argument. It just has to be a contract of whatever nature. And then one must apply the ordinary contractual interpretation principles. 23 is particularly important. It sets out 3 points of principle which his lordship derived. First, that the fact that the construction contract is retrospective in effect is not a bar to it being a construction contract. It is common for contracts to be finalised after the works have started and to be retrospective in effect to the date or even before commencement. If that is what is the effect of the parties' agreement, then that cannot prevent it from being a construction contract. Put another way, a construction contract does not have to be wholly or even partly prospective. B, his lordship warns of taking care not to impose an overly syntactical or straitjacketed interpretation on section 104. It is, his lordship says, a broad expression, and one should be able almost invariably to determine from the contract whether it falls within those words. And C, usually and possibly invariably, where one party to a contract agrees to carry out and complete construction operations, it will be an agreement for the carrying out of operations. My lords may recall, this is, under Part C, this is where the respondent in its skeleton argument crosses out the words and possibly invariably and adds in the words about payment in return for payment. we would respectfully say that each of those propositions which Mr Justice Aikenhead derives are correct, and would respectfully suggest they should be endorsed by this court. What we then
says that he says one can draw the following conclusions, and then he sets them out. Usually, when you do that, there's been some stuff before from which you are drawing those conclusions.
Yeah.
I don't, in fact, think there has been. In other words, these appear to be standalone general approach as a matter of. Well, the first two appear. The first is to do with timing. The second is no straitjacket, and the third is the broad proposition, which Mr. De Gregorio says no, that's too wide.
Yes.
But it doesn't. It's not based on anything previous in the judgment, I don't think.
There was. I've looked at the skeleton arguments, or at least one of them. There was argument along some of the lines of the points I picked up with the court earlier, i.e., how broad Section 104 should be, whether there just needs to be one contract under which those works are carried out.
Right.
So I can only assume that the judge has derived it as a result of that argument.
All right. Well, anyway, that's.
Well, it's a consequence of the fact that the judge hasn't set out, and very often it's welcome, the arguments that have been heard in that case. I mean, you're not prepared to accept that these propositions didn't come from the white heat of forensic argument. They just simply came, as it were born from the judge's mind.
No.
They were relevant to the case.
Yes, that's right. And moreover, even if they did just come from the judge, as it were, I would submit that they are respectfully correct.
Yeah.
My Lord Justice Coulson has summarised each of the points being made. And at point C, if I may, in addition, say, what I think the judge is getting at there is that where the terms, the express terms of the warranty, are using the language which is used in the Act itself under Section 104, which I say is the case here, then usually and possibly invariably that will be construed as a contract for the carrying out of construction operation. My Lord then went
on. Because on the face of it,
yes.
C looks so self-evident, you wonder why he's bothering with it. But in fact, it makes more sense if it in fact comes from argument, and in particular argument about a warranty along the lines that we're having.
Yes, quite, my Lord. And when I take the court to paragraph 27, which is the court's more detailed analysis on the construction, one sees the importance there of point C, where that wording is used, and also the prospective nature of it. So if I take the court to paragraph 27...
And it's paragraph 27 and 29,
yes,
which the learned editors regard as the ratio of the case.
Yes.
Yeah.
And at paragraph 27, my Lord, I have no doubt that this particular warranty was and is to be treated as a contract for the carrying out of construction operations. Paragraph A, the court noted that this was a bespoke, not a standard form. B and C, the recital set out the underlying contract as being for the design and carrying out a completion of the construction.
You say A is the same here?
Yes, A, yes. I will say, as a matter of reasoning, A through to L
Right,
are
so
the same.
it's not an off the peg.
No, quite. Yes. So A applies to our position as well. B, the recitals set out the underlying construction contract as being, quotes, for the design and carrying out a completion of the works. And we saw how the recitals in our case set out in some detail the contractor's definition, design and construction of operations. And C, the wording is replicated in clause 1, which relates expressly to the carrying out and completing of works. And just as a reminder, point 1 was, has carried out and shall carry out. Point D and E, it's concerned with the operative terms of the collateral warranty, referred to in the past as well as the future. So the judge plays particular emphasis at point E on the points relating to past as well as future. This recognised the fact that the works under the contract remain to be completed, and he goes on to construe each of those verbs which are used: warrant, acknowledge, undertake. In F, his lordship states that there were terms to carry out and complete works. Here, using with the opening phrase undertaking. In G, the nature and substance of the terms was to give rise to ordinary contractual remedies. So this comes back to our remedies point. What the court said is the collateral warranty, being contractual in effect, will give rise to the ordinary contractual remedies. Thus, if Lang O'Rourke, the contractor, completes the works but not in compliance with the employer's requirements or standards, there will be an entitlement to claim damages because there will be a breach of contract. Similarly, there could be remedies if Lang O'Rourke had repudiated the contract, because it will then have failed to complete the works at all. It is at least possible that in those circumstances, Parkwood would have had locus to seek injunctive relief in terms of a mandatory injunction, albeit that is often difficult to secure such injunctions or orders in practice when they relate to the execution of detailed and extensive construction work.
Mr. Owen, can I ask you this?
Yeah.
What if that subparagraph, G, overstated it? What if this court concluded that under a warranty you get damages for breach?
Yeah.
And that the remedies are not the same? I know you said
yeah.
they are, and you've made your submissions on that, but say we were against you on that, and so effectively you could take out G or reword G from this list. What difference does that make?
It makes no difference, my lord, for this reason. Section 104, the test under 104 is not set or framed by reference to remedies. What it's set is by reference to obligations for the carrying out of construction operations. There may be all sorts of reasons why parties do not get particular remedies arising from particular facts, but Section 104 is not concerned with that. It's concerned with obligations. Paragraph H, there was no exclusion of liability for non-completion. It was a contract. It was not a contract merely limited to quality of work or design. And similarly here, there's no exclusion or suggestion that if there were a failure to execute the works at all, that there would be any exclusion of liability. And the court makes clear that the contract is not merely warranting or guaranteeing a state of affairs, a past state of affairs. It is providing an undertaking that Lang O'Rourke will actually carry out and complete the works. Completion of the works is not only important so far as time is concerned, it is also important because Lang O'Rourke is undertaking that the works will be completed to a particular standard or quality.
And I suppose you'd say that the reference to undertaking makes no difference either.
Yes, it's no surprise that in that contract where there are three verbs, his lordship had to construe that. Here, it says warrant. It's simply a promise. It's a contractual promise, and that's all one requires for the purposes of Section 104.
I think although the judge below makes the point about the different verbs, that is not part of his reasoning when you get to the part in which he concludes that this is not a construction contract.
Well, that's quite right. I'll come on to that point. The ratio of that decision is based purely on timing. And it's paragraph 27.
On the face of it,
yes.
Subject to what Mr. De Gregorio submits, I'm speaking for myself, I agree with that.
Yes.
Yeah.
So, my lord, looking at not merely warranting a past state of affairs, I'll come on to some further guidance which the court ventures on that at 28. J, clearly one for the carrying out of construction operations. K, the remainder of clause 1 is consistent, and his lordship says that subclause 3 contains an important prospective element, namely will continue to exercise care and skill, and he points to the fact that the other clauses also provide in those terms. And just as a reminder, could I take the court back to page 70, which has subclause 3. This important feature which the judge is identifying is in the design of the works or any part of the works, insofar as the contractor is responsible for such design, it has exercised and will continue to exercise all reasonable skill, care, etc. Those are in almost identical terms to the warranty we have here, his lordship placing emphasis on the future prospective nature of those words. And point L, the fact that the beneficiary is not a joint employer is not to the point, because there is a preservation of defences, namely that there is no greater liability under the warranty than there would be under the building contract. So, Lord, with that reasoning in mind, whilst the court may take issue with certain aspects of that, including the remedies, and I hear the court on that, that reasoning can be...
That's only me.
Yes, can be transposed.
Could be in a minority.
Yes. Those can be transposed into our case. What one has to do is just really focus on what these terms are providing, and we have that past and future element. It comes within the definition of section 104. Can I turn, please, to paragraph 28, where His Lordship Obiter states that it does not follow from all of the above that all collateral warranties given in connection with a construction developments will be construction contracts. One needs primarily to determine, in light of the wording and of the relevant factual background, each such warranty to see whether, properly construed, it is such a contract for the carrying out of operations. A very strong pointer to that end will be whether or not the relevant contractor is undertaking to the beneficiary of the warranty to carry out such operations. And a pointer against that may be that all the works are completed and that the contractor is simply warranting a past state of affairs as reaching a certain level. What Mr. Justice Aikenhead is saying there is that there may be, collateral warranties in limited or narrow terms, quite different from this case, which provide that the work has met a performance standard. It's quite different to the more extensive terms we have here, and His Lordship was not making any comment on that. And insofar
in that regard, is this not right? 28 is really an expansion of 27I,
yes,
which was him concluding, was Mr. Justice Aikenhead concluding that it wasn't merely warranting a guarantee or guaranteeing a past state of affairs. In other words, he was drawing the distinction, which he then expands on in 28, between the past state of affairs and the warranting of ongoing work.
Yes, quite right, my lord. And that's why I do place some focus, at least, on the wording of our warranty, where with the future obligations retroactively in effect.
Yeah.
What the judge was not saying, but what the lower court in this case, we say with respect erroneously determined, is that if, as a matter of fact, the works have completed, then you're outside the regime of there being a construction contract. My lord, that's Parkwood. Can I turn finally now, and hopefully briefly, to the judgment and disposal? So this is part 6. The judgment is at tab 5, page 48 of the main appeal bundle. May I start at page 48, please? The relevant section of the judgment starts at paragraph 12. 12 and 13 refer to the relevant, construing against the relevant background, and straight away at paragraph 13 as to timing, 4 years after PC, 8 months after remediation. Paragraph 14 reproduces the terms of the warranty. Paragraph 15 reproduces 104, 1 and 2 of the Act. 16 reproduces paragraph 23, the 3 points of principle in Parkwood. 17 sets out the obiter that we've just looked at in paragraph 28, and then paragraph 18 deals with the commentary in Lord Justice Coulson's book, Coulson on Construction Adjudication. This is at page 51 and 52, where that decision is considered. And at page 52, towards the top, 4 lines down, he warned, this is the judge, warned against adopting a peculiarly syntactical analysis, the wide definition of the Act, little hesitation in concluding the collateral warranty was construction contract. This was particularly because the underlying operations was for the design.
Right, we have the
yes.
passage there.
Yes. Paragraph 19.
A rather poor paraphrase.
What we do have at the bottom, my lord, is of that passage is from a broader perspective.
Yes.
If the underlying, you have that point.
Yes. Yes. We're all looking forward to the 5th edition.
My lord, in paragraph 19 we have a reference to Swansea. Paragraph 56. And then there's a recitation of paragraph 27 of Parkwood at paragraph 20. 21, the judge notes that the Abbey warranty does not include the verbs acknowledgement.
Right, so at 21 we get into the
the meat of it.
The meat of it.
Yes. And at 22, the judge finds that although the Abbey warranty refers to a past state of affairs and future performance, his lordship then relies on the overture at 28 as on the timing point. I do not consider the Abbey warranty can be construed. And at 23, stated that Mr Justice Aikenhead seemed, this is in the second line, seemed much exercised by the timing of the warranty being executed before practical completion, so that it partly relates to future works. Pausing there, the appellant does not consider that Mr Justice Aikenhead was much exercised on the timing point. It doesn't form part of the reasoning in paragraph 27 as such. Mr Justice Aikenhead indeed placed emphasis on the prospective elements of the wording. It is indeed right. The judge places emphasis on the final sentence of Coulson on adjudication does not criticise the approach adopted by Mr Justice Aikenhead. It is right that the commentary does not criticise Mr Justice Aikenhead's approach, but Parkwood and the commentary were not directed to this novel suggestion on the timing point.
Right, so
yes.
You say he misidentified the approach adopted.
Yes, so relying on commentary or Parkwood, it was relying for the wrong purpose, effectively. That wasn't part of the reasoning in Parkwood. 24 to 26, we again have a focus on the timing at 24. There is no reference to the retroactive nature of the future obligations. And then at 27, the court ventured guidance as to the importance of the timing of execution. We say respectfully without a principled or authoritative basis to do so. Paragraph 28 deals with the parasitic point, and his lordship states that no one would construe a parent company guarantee as a construction contract. That's quite right, but the court may have seen what I had to say in the skeleton about that. A collateral warranty is an instrument of primary liability giving you direct rights, and in this case we say requiring operations to be carried out. A guarantee or a performance bond, and specifically a guarantee, is an instrument of secondary liability. It responds in the event of a failure by the principal to perform. And at paragraph 29, the wording of the warranty should be construed against the relevant background. And all 3 points mentioned concern timing. The works had been completed 4 years previously. Second, that the remedial works had been completed by another contractor months before the warranty had been executed. And thirdly, when the Abbey warranty was executed, there is no evidence that either party contemplated the possibility of any further construction operations being carried out as a result of any breach of contract.
Is paragraph 30 the ratio?
My lord, yes, it's 29 and 30. Focus on the timing in 29 and contrary to the submissions.
Well, I realise all that's from 21 onwards is a sort of run-up.
Yes.
And a number of points are being made, and I'm just asking you whether
my lord, it is. At 30, one sees.
Whether 30 is just another point that is being made, or whether 30 is the decisive
yes,
point.
30 is, because what it says at the end of this first line is, by the time that the Abbey collateral warranty was executed, and that follows on from what we saw in 29, it was a warranty of a past state of affairs, a state of affairs past or future akin to a manufacturer.
Right, so you say that as that appears to be plainly contrary to the words of the warranty,
yeah.
It was going to need more explanation for But why the words
Yes.
should be not be decisive?
Yes. Yes, so we would expect that the reasoning and the ratio and the guidance ventured, importantly, at 27, is novel, and it's apt to mislead and confuse. It's also, we submit, regressive of the policy, which has developed over a number of years, and the intention of the Act in its broad formulation. The position after Parkwood was well understood by the industry, and the decision of the lower court now creates a new test based on date of execution. The focus on signing, as I've said, leads to arbitrary and unprincipled outcomes, commercial uncertainty and satellite dispute, and with respect, it's wrong and should be set aside.
Does the judge anywhere deal with the retrospective nature of the warranty?
My Lord, no, this was argued some length in the skeleton and orally. There is passing reference to Swansea at paragraph 19, as the court may have seen.
Yeah. But I meant the retrospective nature of this warrant.
No, there wasn't. It was a point. We did raise that point at some length, written and orally, and we obviously place importance on it here again. My Lord, unless I can assist the court further, those are my submissions.
Can I just ask? I'm trying to identify where the touchstone is. Is this a fair characterisation? It may need to be refined. Of the question that we need to answer, did simply agree to carry out the works? Did simply agree with Abbey to carry out the works as a separate and freestanding obligation owed to Abbey, or did it warrant that it had complied and would comply with its obligations under the contract? Is that a fair representation of what divides you?
Well, it's getting there, but it's not quite there.
Okay, can you improve
the hesitation I have is use of freestanding contract. It gets into it causes concern with the one contract, two contract points. What 104.1 says, and I just remind myself, an agreement for the carrying out of operations.
That's what I was trying to capture.
Ever so slightly broader than what my Lord has just said.
Doesn't say for the carrying out.
But it imports the idea that a contract for the carrying out of works includes a direct obligation between the relevant parties, which here are simply an Abbey, to carry out, rather than the alternative, which I feel a bit more comfortable about my formulation of, which is warranting that it would do what it was meant to do under the contract.
Yes. For the carrying out of operations, it is, I would suggest, broader than the stark position of does it undertake to carry out works.
Well, speaking in time for myself, I know it's you finished your submissions, but I think I would find it very helpful if we could have the ON and indeed the opposing formulation of exactly what the dispute is, because I think in the formulation of where the fault line, where the divide lies, we may find the answer, or we may find a route to the answer.
Oh yes.
But not now. Before the end of the day, if possible. Thank you.
But in all event, on the timing point, you would say that Section 104 does not say an agreement for the carrying out of works in future.
Quite. And I dealt with that in my submissions earlier. It's not limited to future and past, but what we would say is that the future obligations, retroactively interpreted, certainly do fall within for the carrying out of works, because they are squarely within Lord Justice Stuart-Smith's definition, or the slightly wider definition.
Thank you very much. Yes, Mr. De Gregorio, do you want 5 minutes now, or would you like to think about the point that's just been raised and hit the ground running at 5 to 2?
My Lord, I'm happy to start now if that's convenient.
Very well.
Well, as if I may, before starting my submissions fresh at 2 o'clock, just address the point that's been discussed, because I think certainly we accept that is a crucial point in the appeal to identify where the dividing line lies between the parties on that point. As my lord identified, it's about the question of what the word "for" means. Certainly, for many contracts, it's immediately obvious whether they are or are not a contract for the carrying out of construction operations. What we have with collateral warranties is a certain category of rights and obligations and a purpose for which collateral warranties are entered into, which gives it a character that makes it very difficult to answer what should be a simple and straightforward question. Is it a contract for the carrying out of construction operations? So it does, in our submission, come down to what is meant by "for." And the answer the respondent gives is one looks at both the nature and purpose of a collateral warranty to see whether that fits within the definition. But before that, one looks at the wider structure and purpose of the Act. Because in this sense, applied to a collateral warranty, there is a degree of ambiguity. One can be guided by what the Act says construction contract ought to contain and what are the essential provisions. So after the break, I propose to go through the purpose of the Act, collateral warranties, to come back to this point. But in a nutshell, what and my Lord Justice Stuart-Smith expressed it far more eloquently than I have thus far. The respondent's position as to what that means is it's a contract under which the construction operations are carried out. And we say that doesn't require any reading in of words into the Act. It simply gives the words "for the carrying out of construction operations" their natural meaning in relation to the question that is thrown up by a collateral warranty. Just in the same way that a contract for services, it's the contract under which the services are carried out. And it may be there's a more sophisticated, that the definition can be teased out in a more sophisticated way. And
if it is to be, then we will be relying on you, because this was not a point raised before the judge. It's all completely new. If you are rewriting the Act such as "for" means "under which," then if there's a more sophisticated way of doing that, then speaking for myself, I'd be interested in it, because I think this potentially is the most important point on the appeal.
Yes.
And therefore, I don't think you should be relying on us to come up of our own thinking with more sophisticated ways of expressing the dispute.
My Lord, I will reflect on that over the short break. I'm grateful.
All right, is that a good moment?